Thank you so much for your time. And this is one of the special interviews, I must say, that we are opportune to also have an important personality to talk to, especially on issues surrounding judiciary, judicial matters, judicial processes in Africa, and particularly in West Africa. My guest today is an important person who will be telling us why the African countries are so much at the neck of the ICC and what can be done to appease these countries, especially the AES countries that have also given their notice of withdrawal from the International Criminal Court. Well, he is a Senegalese and he is the acting prosecutor at the ICC. Maybe I can say a barrister or lawyer, depending how you want it, Mame Niang, and he is here to talk to us about all of these issues that you've heard. Thank you so much, sir, for your time, and it's really a pleasure to have you on our station.
Yeah. So thank you for having me. It's also a pleasure to be with you.
Indeed. Well, there are so many issues, as you've heard, relating to Africa and the ICC. Mm-hmm. Let's start with West Africa, where the Alliance of the Sahel States have given their notice of withdrawal. How concerned is the ICC about this?
It's, I should say, very concerning, because as an African, what I can say is that Africa was at the forefront of the establishment of the ICC. ICC count 125 member states, among them 33 of them are from Africa, making Africa the biggest group that constitutes the Rome Treaty, as we call it, or the ICC. To see that, I think that three Sahel Africans who have given notice to withdraw can only be concerning, because I think that we all know that we need international criminal justice. Mass atrocities have been committed in a number of places, and those mass atrocities need to be addressed. They need to be addressed, so that we owe, that's the least we owe to the victims. And of course, if the state are not able or are not capable of addressing that, ICC is there just to fill that gap.
But they say that they want an African ownership of justice. How possible is this?
No, it's possible, and I think that this is where the misunderstanding starts. I think that the existence of the ICC does not call into question any domestic or regional court. They can exist alongside each other. And that's, if you want to understand what ICC stands for, ICC is really here only to fill a gap, particularly a judicial gap. If the domestic system is capable of addressing the need for justice, and if also a regional court is here, we will be very willing and very pleased to oblige, because that's really the heart of our mandate. Our mandate is really a stopgap mandate, to fill the gap if there is any. So then, yes, in fact, we are the very first one to encourage even the development of a strong judicial domestic system, or even a regional system.
Would you have a point, sir, to say if these countries that they should not leave, because they are also experiencing serious allegations of abuses in the fight against jihadists?
Yes. So I think that, that may be part of the fear, but again, we have a clear mandate, and for now, I think that be it in Mali, and I think that we don't even have a situation, for example, open in Niger or Burkina Faso. So meaning that fear is misplaced, because we don't have even a situation. And in the context of Mali, we have been involved in active investigation, but those investigations were mostly, in fact, or exclusively turned towards some of those jihadists, particularly with respect to what happened in Timbuktu. So here again, I think that if there is fear, that fear, I can say, has been misplaced.
Would you say the fear is what may happen after if they eventually go back to democracy.
Yes, but then, even then, I think that there will still be communication. As I say, every country, particularly when you go back to democracy, at one point you may, in fact, need to come to terms with your own issues. And if that happens, ICC is not the enemy, is not even the adversary. ICC can still stand as a reliable partner. That's what we do. For example, we are in Central African Republic, so there is a special court. So we step back willingly to let them deal with their own internal issue. And on the top of that, we even provide some help in some capacity building. And that's something we can do elsewhere.
There's so many accusations that cuts across African countries, and one of them, closer to the Sahel, is Chad. They've also given a notice of withdrawal. And part of what they are saying is that the court has been ineffective and has disproportionately targeted African countries in terms of its cases and investigation. So I will ask this big question: is the ICC unfairly targeting Africa?
Here again, I think that there is the same misunderstanding. One can say is that ICC indeed has been present in many African countries, and maybe for the first 15 years, it was even dealing exclusively with African situation. But what people forget or neglect to say is that in all those situations, be it in Mali, be it in Cote d'Ivoire, be it in Uganda, be it in DRC, in all those situations, ICC did not just come forward to tackle those situations. It did so at the request of the government of those countries. So now to say that we are interfering or we are meddling unfairly with those business, I think that does not do justice to the reality. It means that in those countries, the only cases in which I think that was not upon the specific request of the country was in Libya and in Sudan. And in those two situations, that was the Security Council referral. And when you know the mandate of the Security Council, the UN Security Council, when peace is threatened, that's their mandate. To say that, look, we have the executive power to assign, to even use force. And that was the mandate of the Security Council, to ask us to look into those situations. Apart from, so in this regard, I think it's a little bit, it's very much misplaced to criticize ICC for meddling or interfering unduly. That was upon the request of those states. And the other thing is that, and this I have always said as an African, if the real question is that some of those situations, you look at them, do they deserve or not to be looked into? If you see what happened in Mali, in Timbuktu, I think that the Malian was the very first one to want this to be addressed. If you look at in the 2010, 2011, what happened in Cote d'Ivoire, was it worthwhile intervening? Cote d'Ivoire asks us to do that even before becoming a full member. They accepted ICC jurisdiction even before ratifying the Rome Statute. In Uganda, that was the government, exactly. So, in my view, if you just look at what happened, the human tragedy that happens there, so one cannot say that we didn't have space to do that. But of course, when it comes now to effectivity, I think that I can accept that in every situation we could do better, we can do more. But at the same time, also, we cannot have it both ways. You cannot ask us not to interfere or not to intervene, and when we intervene, you indicate that this is not effective enough. Our effectivity rests a lot on cooperation of state.
How does the ICC work in this case? If you talked about not interfering in issues of countries across, particularly Africa, which we are talking about, do you wait for notification from the country of where the case is originating from, or your prosecutors make a case for these countries? Okay,
so there are at least three ways that can trigger our intervention.
Okay.
One, of course, is at the request of state. That's what we refer to as a referral. A country, of course, can refer us, but provided it's a country that is already a member, because all begins with a country that has accepted to be willingly part of the Rome Treaty, because it's a treaty. Okay. A treaty is just like a contract. We have 125 countries that have created and those that have accepted to be part of that venture. So if now among those 125 countries, there is one situation among them, and a member state refers that situation to us, so then that gives us ground to intervene. But if there is a situation as well, we receive communication, including from private person or civil society, then the prosecutor can also look into the information provided, and if to ascertain whether mass atrocity crimes that can be characterized as crimes against humanity or war crime or genocide, if that happens, the prosecutor can act voluntarily without even the referral. That's what we call acting proprio motu. But when he does that, this is subject also to judicial review, meaning the judges, we need to seek authorization to the judges to do it. And the third way of doing it is the Security Council. The Security Council, seeing that peace is in jeopardy somewhere, can ask us also to intervene. But in all of those three situations, we as a prosecutor, we act independently, meaning that we review the situation, and if we realize that, yes, serious crime may have been committed, and then we can start investigation.
Okay. Now, from all of these points that you've mentioned, there seems to be a strong accusation, which is that the ICC tends to have more African leaders prosecuted than people of the West. Is this case the truth?
I think that there are different ways of looking at it.
Okay.
So, as I indicated, if African countries have themselves call upon ICC to come and look into those issues, I think that it's no longer a matter of counting how many of them. The matter is whether where we have intervened, we were called upon, or we had a legitimate reason. As the saying goes
is it the same application for whether you're a Western leader or an African leader?
And I think that one of the misunderstandings is that, we are not the gendarme of the world. Okay. We are a treaty. So meaning that, mass atrocity can be committed elsewhere, and we even have no business of doing it because it happens somewhere where the member state, the party involved are not member state. Look, for example, what happened in Syria. Even if we wanted to intervene, we wouldn't intervene because just as the country is not member state and there is no Security Council referral. Look at what is happening between, for example, the US and Iran. This is something, of course, that could be worthwhile intervening, but do we intervene? No. Neither Iran nor the US are member state of ICC. It means that, so then I think that for people criticizing ICC for being very interventionist, sometimes there is not a clear understanding of our mandate. At the beginning, there is a willingness to be a member of this venture to begin with. So, for those who have not been, are still not member, unless there is a particular situation, for example, like Palestine, for example, because Palestine is a member state. Palestine had the authority, the legal authority, to request us to look into what happened in its territory. So this was not about now, for example, violating the sovereignty of Israel, because Palestine has been recognized as a member state. And I think that for people criticizing us for meddling too much, I think that there is this lack of understanding of how we work.
But in all your works, do you think that the ICC has been able to deliver justice for African victims?
My honest answer is that we could, or we should do more. We should do more because when you look at all of the victims, because we deal with mass atrocity crimes. So meaning that just the direct victims are always counted in the thousands or sometimes even in the hundreds of thousands. It's difficult to deliver justice to all of them. And I think that if I want to be honest, I would say that we fall short of delivering justice to all of them.
Why is that so? What stalls these processes?
No, because I think that ICC, I think that there are some limitation in the mandate, beginning with how can you even call upon all of those hundreds of thousands of victims to appear in a court of law? That's impossible. So meaning that, in a sense, what we propose and what we are able to deliver is almost always a token justice, not a full-fledged justice. But it's just a link to the nature of those crimes and the number of victims. So we organize ourselves to make them have some representative, and when we investigate, we can have arrest warrant issued for people who we deem responsible for the mass atrocities. But what you need to know also, once this is done, we already reach a first limitation in terms of arrest, because we have no power, no authority to go directly to any countries to perform arrest. We remain very much 100% reliant on the domestic law enforcement. So our efficiency is the efficiency of the states that are willing and able to help us. So, and you see here that if we are being criticized of not being effective, in fact, the critic should rest elsewhere, because the part of our mandate, we have limitations that the very member states have placed on us by not accepting, by not relinquishing their sovereignty, and by not enabling us to come into a country and to perform arrests. This is their exclusive province, and this is, of course, an objective limitation to our action.
But what will happen if an African court like the ICC is set up? How do you think this will play out? No, but
that would be the same. I think that any court of that nature, I think that will also face similar limitation. But again, let me be clear. We are not against the setting up of a regional or sub-regional court. On the contrary, we support those mechanisms. We believe that the main issue should just be to bridge the impunity gap. Whatever court we may come up with, and that can help in bridging that impunity gap, I think that would be most welcome.
Now, for African leaders who may want to pull out from the ICC, do you think this will weaken the ICC if, as you mentioned, Africa has a large number of signatories in the treaty? If all of this decide to pull out, what happens to the ICC?
No, even if only one pulls out, I think that yes, the effect is bad, if I can put it that way, because I think that ICC is strong by the strength of its community, and when you have community today, I think that one of our pride is to be almost a universal tool. Many people, I think, that confuse us even with the United Nations. We are a separate treaty. We are not the United Nations. But that confusion, I think that was something already great, in a sense that our ambition, of course, is that, whatever state is member of the United Nations should be member of ICC. I think that that's what is really desirable. If you see, for a long time, the EU, the European Union, that's what they even put on the table. For any country that they seek to join the EU, one of the prerequisites was to be also a member of the ICC, because, to be a member of the EU, you want also to appear as someone supporting international criminal justice. So in this regard, I think that it would really be unfortunate to even see one member, not three, one member of the ICC to withdraw. And particularly when the withdrawal seemed to rest on some form of misunderstanding. So, based on the fear that they may be secretly being prosecuted, which is not true, or based on some criticism that rests on a limited understanding of our mandate. And I think that that's why also it's very good to keep the communication going.
Okay.
Because I think that there is a lot of misunderstanding or misconception about our mandate.
Well, sir, you've mentioned, maybe my final question, you've mentioned that there are some countries that are not members of the ICC, and however many are members of the UN. Now,
Yes.
how concerned is the ICC in terms of global peace and respecting human rights?
No, I think that in this regard, there is no distinction to be made between the UN and ICC, because we stand for the same value. That's why, in fact, it would be much more welcome, really, to see that whoever is member of the UN become member of the ICC, because we do stand for the same value. Global peace, you remember after the Second World War, why the UN was put in place? That was exactly to make sure that no war will ever take place after the human tragedy the world witnessed. In fact, that was upon the same basis, so to speak, that ICC was also created. That at least we have a space for to fight impunity and make sure that the mere deterrent effect of the ICC will make peace prevail and with a form of perennity. So unfortunately, of course, we see that human beings sometimes can be forgetful, and what we thought that will never happen again is happening in our eyes. But this is one more reason, of course, to reinforce, not to weaken ICC or the UN.
Well, sir, finally, what is the update as regards the warrant to the Israeli president or Prime Minister Benjamin Netanyahu? What is the update from the ICC?
Yeah, I think that this is an active situation. We are still investigating.
Okay.
That's a situation we investigate. Yes, we already have a number of arrest warrants from both sides, but of course with the death of some of the leaders of Hamas, of course those arrest warrants were vacated. So once now, as I indicated, once now we issue arrest warrant, it's incumbent upon state that receive notification of those arrest warrant to execute them. So they are still active, and that situation also is still under investigation.
Indeed. Prosecutor Mame Mandiaye Niang, thank you so much for your time, and we truly appreciate you honoring our invitation.
Okay, thank you very much.
Thank you, sir.